So you asked me what the process is with regard to advocating a personal injury case. Well, first you bring in the client or you meet the client and you do an intake sheet. You find out what the facts are, what the injuries are, all the players involved, all the medical providers involved. If it's a police excessive force case, what police are involved, all the underlying factors. Then, depending on the type of injury it is, it's either going to be one that you're going to try to resolve because the injuries are clear, the value is clear, and the policy limits are not high. So you don't want to waste the client's money and file a case and spend all this extra money and expenses if you know that based on a good liability and based on the injuries, it can be settled. So in those cases, though, you get the records, you get the medical bills, take a couple statements, and negotiate with the adjuster for the insurance company, and most likely you can resolve the case. However, where the injuries are significant and severe, and you know they're not going to be okay in a few months, that it's going to be an ongoing treatment, or if there's some attempted defense to the case, well, then you file it. And you file a complaint alleging what the wrongful conduct is. Then the defendant, through their insurance company, through the attorney they hire, will file an answer. Then we proceed to file written discovery, questions to each side. Usually the defense asks things like, what are the injuries, any pre-existing injuries, treatment acquired, and then we ask a variety of similar things having to do with, did they get a ticket? Do they have any statements? And then we proceed to take depositions. Take the deposition of the plaintiff, the injured person. You take the deposition of the defendant, the driver who wrongfully caused the injury, the doctor who committed negligence, the construction company foreman who failed to take the proper precautions. And then you take witnesses' depositions. And then you take other depositions depending on how complicated the case is. And then you go to medical. Depositions of the doctors, depositions of the therapists, depositions of any medical providers that had treated the plaintiff before for any pre-existing conditions. Then we go to whether or not there's expert discovery. Like on police excessive forces, I would disclose an expert in police policy and procedure. Or in medical negligence, I would disclose doctors to say that the defendant doctor failed to engage in proper care. Sometimes you have to do that with regard to auto cases or truck cases. But usually if someone goes through a red light or someone goes through a stop sign, doesn't really need a lot of expert testimony. Again, it depends on the complicated nature of the case. And then you have trial, where you have to pick a jury. And that's the interesting aspect, because everyone comes in with a predisposition. And our job is to make sure that we don't have a juror who's not going to listen to the evidence and who's going to already be predisposed to say, hey, I don't believe in lawsuits, or, they shouldn't get anything because they have been brainwashed on TV that litigation is bad. It's funny, everyone poo-poos attorneys, especially personal injury attorneys, until they need it. Your recovery is always our focus. Call for a free case assessment at 312-726-6722.